Let's talk about another Supreme Court decision, Abelman versus Booth. How important was that case?
Right. So Abelman is really a very interesting case also. This is 2 years after Dred Scott. So Dred Scott's case is 1857. Abelman is 1859. When we do think about Abelman, or when we do cite it, we say that it was one of the most nationalistic rulings of the Supreme Court, and it was. In the case, basically, Chief Justice Taney and a unanimous court held that the Wisconsin Supreme Court had to follow a ruling of the Supreme Court of the United States. But what was at issue in the case was, once again, the enforcement of the fugitive slave law, slaveholders' rights. And so what that case actually meant was that the full force and power of the federal government was going to be used to make sure that slaves were sent back to their owners in the South, and therefore that the rights of Southern slaveholders were going to be upheld. So it solidified this whole notion of the pro-slavery constitutional order. It might be best to really think of Dred Scott versus Sanford and Abelman versus Booth as kind of a 1-2 punch, both of them arguing for this pro-slavery constitutional order.
So let's talk about Abraham Lincoln and the Republican Party. What role did they play in transforming the Supreme Court during wartime?
Right, and this is a very interesting question because Lincoln comes into office in 1861, and when he's sworn in as president, he seems to recognize 2 of the 3 of these Southern slaveholders' rights. He says when he's sworn in March of 1861, he will not interfere with slavery in the Southern states. He says also that he will enforce the fugitive slave law, but he is not willing to accept the court's ruling in Dred Scott. Therefore, he doesn't think that slaveholders have a right to take slave property into the West. And it's on that question then, of course, that Southern states see that their rights as Southern slaveholders are being violated, and they choose to secede. So Lincoln then, once the war starts, still seems to recognize that Southerners have some constitutional rights as slaveholders. And yet, Lincoln is personally anti-slavery. And we know this back from writings going back into the late 1830s, into the 1840s, that he had said many things that showed that he was personally hostile to slavery. And yet, as a constitutionalist, as a constitutional lawyer, he felt he was bound by the text of the U.S. Constitution. And so Lincoln in 1861 and 1862 is struggling. He's looking for a way to figure out how we can take some move against slavery in the Southern states at the same time that he's faithful to the constitutional text. And of course, war makes it possible for Lincoln to expand his presidential powers, which he does finally in September of 1862 when he issues the preliminary Emancipation Proclamation, which is followed 100 days later by the final Emancipation Proclamation on January 1st, 1863. So part of what's going on is Lincoln has found the constitutional means through wartime presidential power to try to interfere with the institution of slavery and to challenge this notion of slaveholders' rights. He also knows, though, that if that change is going to be permanent, that he's going to have to change the Supreme Court, because Roger Taney is still there in 1862 and 1863. So Taney doesn't die until October of 1864. So Lincoln and the Republican Congress are very interested in ways of trying to redraw the circuits so as to shift the sort of sectional power on the court from the southern states to the northern states. Ultimately, of course, they're able to do that, and that means that the court, by the time Lincoln dies, is mostly a Republican court. After Chief Justice Taney dies in the fall of 1864, Lincoln is able to, of course, pick Salmon P. Chase as the new Chief Justice. Chase had, of course, prior to the war, made his living arguing cases trying to uphold the rights of fugitive slaves. So part of what's going on then is a constitutional sort of constitutional transformation in terms of ending slavery, but also changing the Supreme Court so as to solidify that broader constitutional shift.
Interesting, yeah. So we're going to talk about the third stream in your book now, which is about the African American experience. That's a perspective that's been under-examined. You did quite a bit of original research on this topic. Why was it so important to you to give it significant attention in your book?
Well, I think one of the more interesting things about the book is the emphasis on what I call black constitutionalism. I'm making an argument here that we've missed something over the years. Scholars who have looked at African American history have focused on black activism and black abolitionism and the role that African Americans played in bringing about emancipation. But one of the threads that ties all of those things together is this notion of black constitutionalism, which is basically the idea that African Americans too held to founding principles and constitutional values. And we see this as early as the 1790s. We see it in the language of an African American clergyman, Absalom Jones, who writes a petition to Congress in the 1790s. We see it in the writings and pamphlets of James Forten, who was a free black man from Philadelphia in the 1820s and 1830s. We see it in David Walker. We see it in Frederick Douglass. We see it in the African Americans who assembled in conventions fairly regularly, starting in the 1830s. And the method of assembling in a convention, arguing over issues, issuing a set of resolutions, and trying to promote that through the newspapers, all of that is the essence of this sort of constitutional process. But it isn't simply that they're following this process, it's that they're making reference to the founders. They're citing Jefferson's Declaration of Independence, and they're claiming that principle that all men are created equal as their own. And they're highlighting the absences in the constitutional text. So they're highlighting the fact that the Constitution never actually used the word slavery. And they're saying then that they have rights as persons. And then also Christianity is part of this too, because they're arguing that they have rights as people that come from God. And so all of those things, kind of religion, their understanding of the Constitution, and their view of Jefferson's Declaration, all merged into this set of values that I call black constitutionalism.
So your book goes all the way through to Reconstruction. Tell me a little bit about the Reconstruction Court, the Supreme Court, and their interpretation of the 14th and 15th Amendments.
Right, and this is a very interesting question, and it actually ties in nicely to black constitutionalism in that part of what I argue in the book is that a new discourse of rights comes out of the Civil War, and that this African American emphasis on their constitutional rights pretty quickly drives the political debate from emancipation, which is what people are talking about in 1863, 1864, and of course in 1865 when the 13th Amendment is actually ratified, from emancipation to rights for African Americans. So this notion of rights then is put on the national agenda, I would argue, by this long sort of tradition of African American activism, and that Lincoln and radicals in Congress after the war have to respond to that. And many of them are sympathetic, some are not, and some their views are changing. But the whole sort of nature of how the Constitution is talked about and how rights are being talked about is shifting during and after the war. So the emphasis then is from the rights of slaveholders in the period prior to the war to the rights of those who had formerly been held as slaves. And so we have the 14th Amendment and the 15th Amendment. So then to get back to the question that you asked, right? So the Supreme Court then, in the 1870s, is starting to interpret the 14th Amendment. So the 14th Amendment basically gives civil rights to all those who are born in this country, and they're now deemed citizens of this country. The 15th Amendment, of course, means that states are not able to interfere with voting based on race, color, or previous condition of servitude. So that whole language of rights is all a part of the 14th and the 15th Amendments. The Supreme Court then has to figure out what those changes mean. And in 1873, in the slaughterhouse cases, the Supreme Court, for the first time, is going to interpret the 14th Amendment. The slaughterhouse cases, I would argue, have been slightly misunderstood by some scholars. Some scholars have emphasized the shortcomings of the court's ruling in that case, because arguably what the court did was to define some of those constitutional rights rather narrowly. Yet there was still room, if you read Slaughterhouse closely, and there was still this expectation on the part of the court in 1873 that with most of the Reconstruction government still in the hands of the Republican Party, that state governments would do a sufficient job of being able to protect rights of those who had previously been held as slaves. So there's Slaughterhouse in 1873, and then a pair of cases in 1876, Cruikshank and Reese, that also, to an extent, place limits on the rights of African Americans. But I would argue that this is not something that follows in a straight line. In other words, you can see other rulings in the 1880s, especially Ex parte Siebold and Ex parte Yarborough, where the Supreme Court is perfectly willing to uphold the voting rights of African Americans. So part of what I try to do in that Reconstruction portion of the book is to say that it's not really clear when Reconstruction ends. Scholars frequently want to focus on 1873 or 1876 or 1877, and yet there's ample evidence that the Supreme Court and the executive branch are interested in trying to enforce the constitutional rights of African Americans well into the 1880s.
You used a lot of original sources in your research. Can you just name a few of the documentary sources that you found that were particularly rich, that helped you?
Well, I think some of the things that were most interesting were the minutes of these black conventions in the antebellum era. As I think I mentioned, this starts in a Philadelphia convention in 1830, and fairly regularly then there are these meetings of African Americans. And it was fascinating to read those minutes and to see what they were arguing about, and to see how they voted, and to see how they were citing Jefferson's Declaration and making constitutional arguments. And if there was anything that pointed out this culture of constitutionalism to me, it was seeing the language of African Americans in the 1840s and 1850s, where they were making constitutional arguments in opposition, for example, to the Supreme Court's ruling in Dred Scott. So we might think off the top of our heads that, well, African Americans just had to accept what the court said in that case. And yet there were a series of statements issued by African Americans who assembled in these meetings in 1857 and 1858 saying things like, shame on Judge Taney. He didn't get it right. And if he had actually read the Constitution, some of these African Americans claim, then he would have understood that we had these rights. And so they're citing the guarantee clause that guarantees a Republican government in every state. They're citing the Privileges and immunities clause, not the one in the 14th Amendment, but the one that's written into the U.S. Constitution. And of course, as I said, they're always citing Jefferson's Declaration. So based on these constitutional principles, African Americans don't simply accept what the Supreme Court has ruled in Dred Scott. So sources like that were really interesting, and I tried to mine those thoroughly.
That's fascinating, yeah. So my last question to you is, what might a reader who's very familiar with the Civil War be surprised to find in your book?
Well, I think there are a number of things. Certainly this notion of a culture of constitutionalism. I mean, I am taking issue really with those who have largely kept the constitutional story out of the history of the Civil War. And I'm trying to bring it back in, but not in the same way that we've previously understood it. We've previously understood constitutional history in the Civil War mainly through the work of the Supreme Court. I'm arguing that it's something deeper, that it's something more nuanced, that it's something more pervasive than that, and that this culture of constitutionalism really is at the heart of the sectional struggle. And then I think the other thing that fits with that might be surprising is really this shift that I emphasize from the antebellum discourse of slaveholders' rights, which is what everyone's talking about, certainly what the court is talking about in Dred Scott and Abelman versus Booth, versus this wartime and post-war new sort of discourse of rights that focuses on African Americans claiming all of the rights that they thought were inherent in citizenship and personhood. And so this shifting discourse of rights is one of the significant points of the book. I mean, who would have thought in 1860, on the eve of the Civil War, when all of the power of the federal government was being used after Abelman to uphold the rights of slaveholders, who would have thought that within a decade, by 1870, after we have a 13th Amendment, a 14th Amendment, and a 15th Amendment, and two very strong federal enforcement statutes passed in 1870 and 1871 to give the federal government power to enforce the 14th and the 15th Amendment, who would have thought that really over that 10-year period that all of the full force and power of the federal government by 1870 would now be used to uphold the voting rights of those who had previously been understood under constitutional law as mere property, who had no rights, which was, of course, what Roger Taney famously said in 1857. So it's that shift, I think, that's really interesting, and in some ways is surprising if you frame it in that way.
Well, Tim, your book reads beautifully. I really enjoyed it, and thank you so much for talking with me today.
Well, thank you very much for having me. It has been a pleasure. Thank you.